Hi guys, welcome back to my channel. My name is Ksenia. I make videos for people who are going through the family green card process. I'm not an attorney. My videos are based on public information, my own experience, and the experience of my subscribers, and the purpose of my channel is to give you guys the confidence to go through this process completely on your own. There has been an article circulating from NBC News, as the one you could see on the screen behind me right now, about a new USCIS policy update that came out, that now, a lot of people are reading this article, freaking out. The articles like these misrepresent a lot of the information that is posted by USCIS. So the purpose of my video today is to give you some peace of mind, once again, about some of the things that are coming out. The purpose of my video today is to go over this update. Aside from just looking at the policy alert itself, I went and looked specifically at the policy manual and compared it to what it used to be before this update was made through the Wayback Machine. So the articles that you're seeing circulating in social media posts refer to this policy alert that was made on August 1st of 2025. USCIS frequently makes these policy alerts anytime they make changes or updates. I'm not going to go over the policy alert itself because we're actually going to go directly to the source. The changes they're referencing are located in Volume 6, Part B, Family-Based Immigrants. So on the left-hand side, you will see what it looked like before these changes were implemented. There was a lot of information actually missing from the policy manual that they simply added. So this is one of the major changes, is making it clear and highlighting to people exactly how they make a decision on your case. So starting with chapter 3, so in the first paragraph, change had to do with them defining a U.S. national, which prior was only listed as a U.S. citizen or lawful permanent resident. So they do include U.S. nationals. And again, that is not new information. This has been in the form instructions for a long time. The next change that they also included, again, is a procedural change that has existed and everybody knew about it, but now it is specifically spelled out in the policy manual, is that a beneficiary of a family-based immigrant petition can concurrently file to adjust status in certain circumstances. For example, immediate relatives who are not subject to visa limitations, who is in the United States, they can file their Form I-485 concurrently. Again, this is not new information. This has already existed. And then the next paragraph remained the same, and that is to do with USCIS generally is the agency that processes the I-130, but there are certain limited circumstances where the Department of State can accept the I-130 petitions. These are just procedural things. Again, they have already existed. This is not new information. And they did add a paragraph D talking about multiple petitions, and this is what happens when a petitioner files multiple petitions for the same beneficiary in the same type of category, and how they would normally adjudicate it, how the decision is made. This is a very rare circumstance. This is not really relevant. Now let's get to the part that has everybody worried, and that is Chapter 5, Adjudication of Family-Based Petitions. The newer version of the policy manual still does not have petition review information, which they may or may not add, but they also talk about interviews. They're letting you know who will get an interview after filing the Form I-130. This refers to standalone I-130 petitions, which means you only filed the I-130 and nothing else. But I want you to pay attention to the footnote that talks about specifically here that USCIS will conduct an interview in all I-130 petitions that were filed concurrently with the Form I-485. This has been happening. The interview waivers really kicked in during COVID to alleviate backlogs, etc., which honestly didn't really help. The processing times during COVID were atrocious, even without interviews. Now, as I made clear in some of my prior videos, yes, interviews are indeed back, but that doesn't necessarily mean that your case will go slower. And if you have seen my video where we talked about 2025 cases going significantly faster, being invited to an interview significantly quicker, it doesn't mention specifically for marriage-based or not. It also may include people who are in all other family-based categories. But again, this would, for the most part, only include immediate relatives of U.S. citizens because they are the only ones that at this moment are eligible to file I-130 and I-485 at the same time. Next, let's talk about decisions. So the approval part of this has not really changed, but let's talk about denials. If you read the policy procedure that existed before and now, you will notice that the denial piece of it didn't really change. USCIS may deny without first issuing an RFE or notice of intent to deny. Yes, this sentence seems scary, but do please pay attention to the second part of this sentence, which says, if there is no legal basis for approval and no additional information could establish legal basis for approval. If you filed a petition I-130 for a relative, for example, for whom a category simply does not exist, they can go ahead and deny this petition because no amount of additional evidence can magically create a category for this type of relative. So for example, a U.S. citizen filing for a grandparent, like they tell you in this part. Of course, it's going to be an automatic denial because there is no legal basis to approve this kind of petition. They can't just create a category for you. And this part right here was added, and that is removable aliens. And that is the part that a lot of these articles are hanging on to. If USCIS determines that an alien beneficiary is removable and amenable to removal from the United States, they will issue a notice to appear, placing the beneficiary in removal proceedings. And they also want to make it clear to you that a family-based petition does not give you a legal status and does not prevent you from removal. This information is also not new. This has always been the case. Filing an I-130 petition basically puts the beneficiary on the radar. If you read who are removable aliens based on the Code of Federal Regulations, I will pull it up for you guys right now. They talk about who are deportable aliens, and all of these people are listed. Of course, people who have violated the terms and conditions of their non-immigrant visa, such as overstaying their visa, are deportable or removable. Again, that has always been the case. So yes, that does sound scary, but you need to also understand that things such as visa overstay or unauthorized work in the United States, so those are the two very common violations by non-immigrants in the United States, are automatically forgiven for immediate relatives of U.S. citizens. This exception has existed for many decades now. USCIS just needs you to understand, just because you file an I-130 doesn't mean that you are now protected. I can't emphasize this enough, that this has always been the case. And also pay attention to the wording that USCIS uses in their manual, that they may issue you a notice to appear. this does not mean that they will automatically issue you a notice to appear. This does affect people who are unable to file the I-485 concurrently with their I-130 petition, who are waiting for their I-130 approval to then continue with the provisional waivers. But again, the viewers of my channel who are doing simple, straightforward, family-based immigration should not be affected by something like this, because again, this is nothing new. In majority of cases, it will not affect you if you are an immediate relative of a U.S. citizen. You do need to be honest with USCIS about these violations and any other violations that you have made. If you are still not convinced, I do suggest that you follow my professional Instagram page, which I will link below. I post people's experiences, so screenshots of people sharing their approvals with me. And I have already hundreds of screenshots from this year alone that I am continuing to share every weekend. People are still applying. People are still being approved. You shouldn't be worried about these headlines that pick out selective information. One of the other changes that they made was adding chapter 4 in this volume 6, talking about documentation and evidence, which, if you can see on the left-hand side, was not previously accessible online. That the burden of proof is on the petitioner. So the petitioner who files the I-130 must establish their eligibility. If the initial filing does not contain sufficient evidence to demonstrate eligibility, USCIS can still issue you a request for evidence, a notice of intent to deny. They will schedule an interview or deny the petition depending on the facts of law. But here they talk about that USCIS will use their discretion to deny a petition without issuing an RFE or NOID if there is no statutory basis for approval or failure to provide initial evidence. Basically, the initial evidence refers to two things. One is the proof of the petitioner's status in the United States, and two, statutory evidence showing how this beneficiary is related to the petitioner. Initial evidence, which means your marriage certificate, if you are doing this by marriage, showing birth certificates, if you're doing it for a parent or a child. If you are failing to submit this kind of initial evidence with your submission, it is no-brainer that USCIS can deem your application incomplete instead of chasing you around to submit this initial evidence, which is required in the first place when you first file your petition. And then if they have additional questions about the validity of your marriage based on the additional evidence that they request, such as bona fide marital evidence, then they can issue you a request for evidence or invite you to an interview. But again, these articles are scaring you for no reason, because this is not anything new. So if you like this video, please subscribe, give it a thumbs up, and I hope to see you guys in my next videos. Bye!